This is Shankar Gurumurthy from NXP. I have Wouter Vanderloop joining us online through Teams. He is he oversees the privacy and data protection compliance within NXP Semiconductors worldwide, and also he is leading this effort within NXP. Yeah. And to talk about myself, I work for NXP for the last 20 years. I'm proud to say I am with Philips and NXP family for the last 20 years. I am currently working with CTO, Chief Technology Office. And I am from the Process Excellence team. I am a process expert, defining and managing the business creation and management process of NXP. And in this session, we will have more details and clear insights from Wouter on GDPR. That's going to be one of the focus area for the first part of the session. And in the second part, I will also give you an overview of the development process, because we always talked about BFSI, healthcare, etc. It's going to be something different for the next half an hour or 45 minutes on the applicability of GDPR in semiconductor industry. So that's the topic we are trying to cover. And I will explain about the development process. In the development process, how GDPR aspects are embedded. So that's going to be the focus for the next 45 minutes. And over to you, Wouter.
Yes, well, thank you for this introduction. And thank you for having me. This is a very nice opportunity to share some of our views, or how we interpreted privacy and data protection within semiconductors. And indeed, I was asked to a bit focus on the GDPR, as we are a European company. So, I already got introduced, so indeed, let me share with that or add to it. We are placed in our corporate headquarters in Eindhoven, within our legal team, specifically within ethics and compliance, as of course data protection is a compliance topic, so to say. I'm with NXP for 2 years now, but this year I will celebrate my 10 years in the privacy and data protection profession. So, and previous to NXP, I did all that more into B2C companies, specifically in the telecommunications sector, and also in the banking sector, where there's of course a very different approach, and that is also what I really wanted to emphasize in this presentation, some of the specifics in the semiconductor industry, as we do not really target that many customers, so to say. Of course, we have a lot of customers, but we are a B2B company, and that is a completely different perspective. Now, what does the industry make so different, or at least what are the things that I've really noticed in semiconductor industry? That it's absolutely truly a global company and industry, with many experts working on things that a lot of people not working with that do not even understand. So there's a broad variety in languages, not in global languages, but in expert language, in technology, which is something that needs to be breached. A global workforce, so to say. It's not that you operate globally and have all these autonomous countries. No, teams are scattered all around the world and they work together. So that's truly something different than in the other companies and other sectors, I believe. Being so global and being so intertwined with each other and having teams all around the world also means that many privacy laws apply. So that is also one thing that makes it difficult. There's also a lot of cultures. That's of course linked to being global. And we are really innovative. We want to innovate. And IP protection. That is, of course, something that is getting more and more important. When we look at the European perspective, because that is, if we look at GDPR, let me see if I can switch my slides. Somehow he doesn't want to navigate, so there we go. And if I look at the title of this presentation, it was about privacy and data protection in semiconductor industry, and that is, I believe, a very important note. So I wanted to keep my presentation not that we go into all the legal text. I assume there are many privacy professionals attending this, and we all know a bit. So I wanted to really focus on what is then different, and especially within Europe. So a lot of people take a look at privacy and data protection, and we all use it synonymously. But actually, there is slightly a difference, because if we look at today, we celebrate, of course, the International Data Privacy Day or the International Data Protection Day. In Europe, it's officially once called the International Data Protection Day, while the rest of the world calls it a Data Privacy Day. Now, you can say this is, of course, because of we just like the word to change, but it is not completely why this is. So today, of course, we celebrate the signing of Convention 108, which was really the first international instrument focusing at the protection of the collection of personal data and the processing of personal data. And that is a very important distinction, because and the convention was made by the Council of Europe, which earlier on, I believe in 1950 or 1953, also wrote something that's called the European Convention of Human Rights. And later on, that Convention of Human Rights focuses on human rights and not so much on the processing of personal data. And here's also very much the difference if we then start to compare these two terms from a European perspective, because the Convention 108 is, of course, written and signed by the Council of Europe, where later on we, of course, also got the European Charter of Fundamental Rights. And that is a different document or a different law that doesn't apply to all the members of the Convention of the Council of Europe, but it applies to the European Union and its members. And with this European Charter of Fundamental Rights, there's there's a small difference between the earlier written European Convention of Human Rights, right, that I earlier touched upon. In the Charter of Fundamental Rights, there are actually two articles, and the one states that is the respect for private life, which is also part of the convention, but we also introduced Article 8, and that is focusing on establishing a right to the protection of personal data. And that is also where the difference comes in these two terms. And for us, that's really important, and where we most talk in companies, we are talking about the protection of the processing of personal data. But by having these two separate articles, we really make this distinction between one, respect for private life, and the other, actually the processing of data related to a person. And that means that also this processing of data about a person is protected as a fundamental right in Europe. And now maybe you're still puzzled by what is then the difference. And I think COVID once brought us a very good example where you see the difference between the right to private life and the right to the protection of processing of data. Where COVID, we suddenly started to measure people's temperature, and it's also a good example that even lawmakers and supervisory authorities sometimes have difficulty understanding the difference. But then there was this discussion if it's allowed to measure somebody's temperature and then to see if they can come into work or at the office or in a factory. And then, for example, our Dutch supervisory authority stated very broadly that that was absolutely not allowed because it was against GDPR. which was not right, because actually only the measuring of someone's temperature and not storing it, not putting it in a system, not doing anything with it, is not processing of personal data, and therefore doesn't fall under the GDPR, and doesn't fall in the scope of our supervisory authority that's stated that. But it is part of the right to private life, right? It's right to bodily privacy, and that is definitely the difference between the two. And I think that is something to keep in mind. Although in everyday life, it's good to not. It's not really required, but I'm saying this because it ends up in some of the interesting discussions that you can have really in our industry. So whenever we talk about the protection of personal data, then it's about actual processing. Now, the it's part of Article 8 in the Charter of Fundamental Rights, but it's further, of course, put into the GDPR. And GDPR then lays down the rules. When you start processing personal data, you need to adhere to the GDPR. That also means that it's often said it's not allowed by GDPR, which is not always the case, because GDPR just applies if you're allowed to process personal data. So that is a bit sometimes a different take. Very important to also address that. We now have GDPR, but it's not like we can lay back, read the law, and we're done, right, by interpreting. No, the law is, and data protection field is absolutely an evolving landscape. And also there, I think this is absolutely, although every country has this, this is very important to know when dealing with European law. The law goes back way long, because GDPR was not the first one. We also had the Data Protection Directive, and also that case law in many times still applies. So we, on the one hand, have the Court of Justice of the European Union, that are the European Court of Justice, also known, that offers case law, and then we have also soft law. We have the EDPB, which is the joint body of all supervisory authorities in the European Union. So that's called the European Data Protection Board, and that writes guidance on how to interpret the law. And if there's no case law available, then you better follow this guidance, although it's not the law. It will be used also when going to court by the Court of Justice. So it's basically guidance on how to interpret the law, and there's many of those guidances. So that's a very important thing, and they write it. For example, we have one on consent, we have one on privacy by design, on the role of the data protection officer, data protection impact assessment, etc., on how to interpret the role, or at least how they would like you to interpret that principle. Now, going back to where I started with the privacy and data protection, it's like I said, well, sometimes it's often used synonymously, and also to very much know that all these terms, data protection, privacy, data privacy, although used synonymously, in jurisdictions is also sometimes just used differently. In the US, for example, they actually use privacy to mean data protection, and data protection is more security related there. So I added also the world, but in this picture, it's all around the world operating. It's also good to really know that there might be a difference in perspective and in understanding. It's sometimes bound to jurisdiction, but the result is that there's also different starting points sometimes. And this is something that is basically the conclusion of the different terms. It's very good to understand where people are coming from and how they interpret the law. Where in the EU, it's actually, when we do an assessment, we start by not processing personal data at all, and then see if it's really necessary. Where the assessment in the US, for example, is completely different, and that's also in Asia. It's completely different, and most likely in India. I think we are more alike in this perspective when it comes, but you try to avoid processing personal data in the first place, and then if it's required, you go and start following the rules, and that is good to keep in mind. for working in a European company, or at least a European headquarters company. I will come back to that in some later slide. If we then look, another difference, which is very important, also bound to the different operating in the world, there's the difference between PII and personal data. Now, apologies for this slide with a lot of text, and I don't want to go through the definitions themselves, but there are two different definitions between the two. And although also used synonymously, they are absolutely different in scope. And that is also very good to understand. In everyday life, it's well, you can use them, of course, synonymously just to make it easy, because people don't like the word personal data, or they want to write down PII, which is quite faster than personal data. But yeah, it's good to know that it might mean something, and that is also the most likely the perspective of somebody. So you need to take that into consideration. The main difference in also the definition is that the one, PII, states any information that permits. Now, I haven't marked that permits, but that is very important, because if you look at the other side, it states any information that relates to, and that is then stated to an identified or identifiable person, which is later really explained what it is. So it separates also the identification and the any information, and that is important. Besides that, of course, PII is not a legal term, so it's used in different and in many other privacy laws and standards, and it has a different meaning. I just took the definition from the NIST, but there are many others. And it might not include all information, and that is what we will see in the next slide. If you take a look in my next slide at some examples, then both terms include absolutely, of course, the direct identifier or the linked information. Very simple: name, social security number. For everybody, that's clear. It gets a bit more vague for people when we have the indirect identifiers, but still people understand that it might be part of it when you have an age, even if it's a range, or you have a place of birth, or very common names that is also not really direct, gender, religion. But there are many other examples. People do understand that that's personal data, and they believe that's it. But the difference comes when we look at the other parts, and that's not even considered PII, and this is where the difference comes. For example, IP addresses, device IDs, browser types that came back from your and other device information, but also exam results can be personal data, and a performance review or the notes of that performance review, somebody's assessment about you, and that is also linked to that case that law is developing. This is one of those examples where personal data is very broad definition, and it's also confirmed by law. So in a very known case law by the European Court of Justice, the concept of personal data was emphasized as any kind of information, but then also objective or subjective, but it also includes that information when it concerns the data subject. So, at least by reason of its content, purpose, of effect. And this is very important. This also makes it the case that exam results, for example, are part of it, and that it's absolutely everything around an individual. And this is a very misunderstood concept within our working field, because this is why I'm saying this, is that people, it's not that they don't want to comply, but they have absolutely not even an idea that GDPR is applicable to them and their information. So that is to take into consideration when we go to the 4 resulting challenges that I previously did not really experience when I was working at other companies. And that is why I relate those to the impact of European law on the semiconductor industry. Now, let me start with, of course, the extraterritorial impact. Now, like I said, I believe that most people do understand already or are knowledgeable about when GDPR is applicable. But yeah, because this is so important, I did add it to the slide, but also not the direct context of the law, because of course internally we can of course state, hey, yeah, the GDPR is applicable when you do something in the context of our headquarters. Yeah, people really do not understand what that means, so we try to make it simple for them. But yeah, if you translate Article 3, Part 1 into how this applies, for example, to NXP, yeah, then it's often when you process personal data of individuals in the EU, when you process the personal data of individuals based outside of EU, but it is in a tool that also includes EU data subjects, yeah, or the processing takes place in the EU. Well, this means, of course, and this is very common knowledge, that GDPR applies, well, to all our global operating, well, at least if there's tools involved, as our teams are all around the world. But if it's a global tool where everybody is in, it will be subjective to GDPR. And that also means that many of our processes need to apply to the far-reaching and comprehensive requirements from the GDPR. And this is combined with the misunderstanding of when something is personal data, really a very big challenge that we face. And that results also in, well, the innovative mindset of our employees versus data protection. We have an enormous company, and they all want to share data. It's been like a very well, at least historically seen, people just want to give the data, right? We want to invent, we want to create, we want to innovate. We need to work together. We are all around the world, so please, here, have my data, and I want yours. And it's not that they don't want to comply. People just want to do what they are best at, and they just want to work with the data. So they don't want to be slowed down by legal nonsense, so to say. And a very miscommon judgment is that we always get, isn't that your responsibility? You are privacy, so you should be compliant. That's not really, that's the beauty, of course, of a compliance role. We need to educate and help people get compliant, but we are not the ones doing it. So to be honest, I do see a slow shift of mindset lately. People do get more awareness, but like I said, it's often more on the unfamiliarity with the rules than that they are really not wanting to be compliant. And yeah, one of the things to really consider is that on the one hand, GDPR has this beautiful framework that's called BCRs. Now, BCRs are binding corporate rules, and they are an instrument not only to allow your, well, third country processing, but also really to create a framework of compliance, of privacy compliance within your whole company worldwide. It's a very, very, very good framework, and it's absolutely something really good. Although getting officially, getting the official BCR signed is a lot of work and very costly. You could also consider BCRs without, well, really applying for BCRs at the European Union. But still, the idea behind the framework is really helpful in having a global compliance mindset and creating this awareness. And a separate option is intergroup transfer agreements, but they lack, well, the requirements behind what you need for BCRs. It is a bit the same, but it is also an option, of course, because you do want to be able to share. But it's also very important to determine the processing roles, which might be very difficult. When is what entity a controller or a processor? There is really something that you at least need to take into considerations, and that might lead to a lot of discussions, but do have a big impact on the way of working. One of the other challenges is IP protection and data privacy. So moving to that one, our protecting our crown jewels is become more and more and more important. And some of the difficulties here is, of course, the monitoring versus, or at least protecting our crown jewels while still preserving employees' rights and freedoms. And this is often a very sensitive topic, depending also on the culture of a country. So this is also interpreted by many different areas in the world on a completely different way. And also in Europe, this is seen differently. And one of the points where you can really see that difference is also the inclusion of works councils. So we do not only have to apply and make it compliant, but works councils are representatives of the company, which we, for example, have in Europe, in Germany, in the Netherlands, and they actually have co-determination rights on these types of initiatives. So they need to approve with it. And then you see there also a cultural difference where in Germany, for example, they have a long history of being monitored and the communism, and you really see that back into their assessments and the way that we need to work together with IP protection to at least preserve privacy. So this is a really really good example, and really a challenge to do right. Luckily, there are many ways to do it, and to briefly sum it up, privacy by design here is a very important thing. Closely be involved while things are decided, and being able to provide some advice there. That's absolutely necessary. Also to be transparent, explain what's going on. This is basically one of the most important things of GDPR. It's not so much that you that it's wrong that you do something. The law is there to, well, at least stimulate even the free flow of data throughout the union. So it's not that you should say no, but you should say, if you do it, do the minimum that is required and explain what you're doing. You don't have to say the rules. That's the same. I can't say what we do for IP protection here, but you should not, the technical working is not required, but you should explain how it works and what people should expect, and also what are the goals. Very important. What do we want to achieve with this processing? Because that brings me to the other point. Then you can focus more on prevention. There's a broad sense of, or at least when you look at guidance and our supervisory authorities, they understand the need for monitoring, and this is not considered the monitoring as really looking actively in people's private and also business mail boxes. But there is something that is privacy on the workforce, and at work we are still protected by our fundamental rights in Europe. So this is really a difficult topic also to explain sometimes, for example, in the US, where they have a completely different view. But if you can prevent or block, for example, that somebody is doing something that's not allowed, that absolutely prevails then the option of detecting it and then trying to actively stop it later on, or really monitoring. If you can automate the blocking, that's even better. Then no involvement whatsoever of somebody else is required. So another big challenge, and this is really something that I've only experienced here, is the need for data. And then I mean the need for data to, for example, test our products or develop our products, or those are the best examples, because we don't sell, as a semiconductor industry, really an end product that often already creates a lot of data. We sell products to manufacturers that put it in products, and then it starts processing data. And often we do need to know if it's working. So we we do want to test our solutions, but also it's no longer that we are only focusing on hardware. The industry is also changing to build solutions and to write software that comes with the hardware, and also to train algorithms. So to do that, you need data, but that can be well.
Sorry to
That also create, yeah.
Sorry to interrupt, Wouter. Yeah, it's a great discussion. Thanks for the insights. But the last 5 minutes, just I am doing some timekeeping here. Yeah, just to mention this. Yeah, last 5 minutes we go with the examples, because the example what you have is also interesting for the team here. Yeah, that also
Yeah,
we will
yes.
cover. Thanks, Wouter. Yeah.
That's fine. I was then I wanted to briefly go to you because we need to ensure timely involvement. Let me skip to that. Sorry. And indeed, I think one of the most important things is that we are there and have pragmatic solutions. And in that case, I want to touch and give it to you, Shankar, so you can explain what we did. I believe in a very pragmatic way. Um, uh, and and tackling the different languages and different professions that we do in a very pragmatic and nice least impact way. So yeah, thanks for having me. Sorry it took a little bit longer.
No, no.
I hope this was fine. Didn't want to go into too much details on the legal stuff, but if somebody has any questions, please feel free to contact me later on LinkedIn.
And also, do you want to talk about this example, what you have, Wouter, on the violations of GDPR, and yeah, what was the impact?
Okay. Yeah, on the violations, yeah, because yeah, absolutely, because this is the risk that we pose. There was already a car manufacturer that was fined in Europe for 1.1 million. That really hurts on using the data in the wrong way, right? So this is actually really not only a theoretical issue. We are really being seen. The industry is changing. And just driving around with a car with cameras and sensors to actually detect, test, train for whatever is not allowed. And there's that it is possible, but you really need to take care of every requirement. And in this case, it wasn't. So the examples of fines that coming to related to our industry are there. Luckily, our industry is still a little bit behind, but you see that this is getting more and more attention, and this is quite recent fine. It was from last year. So I think that is a very good example where we struggle with complying, and also the misunderstanding, because the people here really just tried to do something that they thought was normal. Most likely did not involve the right people internally, and therefore things as transparency were not arranged, right? So the data was stored somewhere. Nobody was informed. They were just driving around and pulled over by the police, and well, they got fined later on.
Yeah, thanks, Wouter. Yeah, it was
Yeah.
really an insightful session, because from the morning we had different topics, and yesterday we had that in a hotel. Yeah, but thanks for taking us into GDPR itself. Yeah, and also the comparison of data privacy versus data protection, and also PII versus personal data from an European company, that is a semiconductor industry, how we look at. Yeah, thanks for explaining us and also giving more insights on this topic. As a continuation from a semiconductor development company, what is the process that we have? Yeah, we all discussed about governance, process, etc. But I would like to show you some examples of the data protection and privacy in the semiconductor development process itself. So when I say process, it's not just about definition and getting the stakeholder approvals. I also define it in 4 different phases. First, you define the process, and the very important step from yesterday we are discussing, deployment. Not only the definition and taking the approval and involving the stakeholders, deployment. Yeah, what we also do is we conduct trainings, we have a university, yeah, and also we are through town hall meetings, the BL meetings, etc., we spread the message. What is the change and what is the criteria and things like that. So that is what I would like to explain. And the third phase is the implementation. After deployment, the teams have to implement. But the fourth important aspect, especially for sustenance, is the quality assurance. Quality assurance and ensuring that it is not just the process is defined and it is static, and also it is continuously improved, and obviously it is implemented in the development process. Yeah, what semiconductor industries have. Yeah, typically every semiconductor company has a management system with a life cycle defined. I will show you some examples also later, where the projects are run in phases. And it should not be a surprise at the end where we get into a legal compliance problem. But from the beginning, the management is made aware on where we are with respect to certain aspects, which also include the GDPR aspects especially. Yeah, because it is also important from the management perspective, because it will cost you more if you left it unattended. So that is the reason the project status is sent to the management. And the quality assurance team also plays a major role here by doing an independent assessment of the deliverable maturity and the process compliance aspects. Yeah? So they use a standard questionnaire, and GDPR checks are embedded through which the process is not only defined, it is properly deployed, implemented, and continuously improved and sustained. Yeah? That's how, in the next slide, I also show you some examples. Yeah? You start from the concept phase, definition phase, planning phase, but as you can see these diamonds, these are the points at which the management comes together and they check whether you are satisfying certain processes where GDPR is also important, where you can also see some major milestones or some checkpoints from the semiconductor industry perspective, which will be familiar for most of you, like tape out and the engineering samples that we make, and also the qualification samples that we make. And in the next slide, as another example of what this is, yeah, what the terms are, and as a next slide, the last one, we also show you to ensure that the legal team is involved. One slide back. The legal team is involved in ensuring that they are involved from the beginning. There is a privacy office, as I was mentioning. Wouter is leading that effort. Yeah. In semiconductor companies, normally they have a data privacy officer. In NXP, it is Wouter and team, to ensure that they are involved. They are consulted, even if they have any questions. Are we managing any personal data? Because personal data comes from two different perspectives. Because we are an European company, we manage European colleagues' data. And from the other side, we also make some services out of these semiconductor components, where also, yeah, we are in a way manageable, yeah, in a way responsible for this data, even though it is managed in AWS, etc. Like we discussed from yesterday, AWS plays a major role there. But we also ensure that wherever the GDPR regulations are to be taken care, the legal team is involved, and we have created a list of privacy champions, yeah, in the team of privacy office, and we ensure that we are in compliance. Yeah, this is how, at the ground level, in the development process, how we are ensuring that GDPR aspects are taken care. Yeah. Now, open for questions. Please go ahead.
Car traffic.
Yeah.
Hello.
Yeah.
Hello.
What that makes it personal data is, of course, the images of pedestrians that are just walking around. So it's about persons being on video, and also driver's license plates of the license plates of a car. Those both make it personal data. I would also argue that I don't know if that's what's meant with the question. If it's either if it's also considered PII, I would argue yes, because a picture really is allowing something to be identified, or to make you identifiable, and it's not so much around it that it's additional information. So yeah, it's both PII, it's both and personal data.
Just ask whether that clarifies.
Okay.
Hello.
A
I guess
question
that
from the audience
clarifies.
here.
If there is a follow-up, then we'll come back. Thank you, voter. Over to audience.
Hello. Industry and the semiconductors and what PII and personally ties there. So apart from GDPR, do we have any specific other laws, like sectoral laws, that you need to implement or make compliance to, because there could be a highest risks involved, right? In terms of personal data.
Yes, absolutely. The data protection is only one part, and it's funny that you ask. I was a bit, well, when I started, what do I want to tell? It was a difficult. I went through some ideas, also really explaining GDPR or indeed more the global, how we have conflicting laws or other laws that are impacting us, and it's sometimes really conflicting. And it's not only privacy laws. I think our biggest risks lie also with other laws, and that makes sometimes the data protection also unknown within the company, right? But we have trade secret law and export controls and all these other laws that are absolutely impacting us.
I have just one query on your
Mike.
ongoing.
You're not taught. Yeah.
Yeah, you told that European Commission on Human Rights, and then the Court of Judge of European Commission. So there is a lot of conflict of something implementation in GDPR as well as the Convention of 108, right? So which is highly privileged while doing that. Any issues? Recently, Ireland, the GDPR violations happened, huge fine in executed. So how the things ongoing when the conflicts happened on two biggest court judgment? Implementing GDPR regulations, ECHR and Court of Judge, right? So which is high privileges, maybe override the GDPR implementations if there are any problems or anything, fine happen, something like that.
Yeah, so the law is regulated at the beginning at member state level, right? So when there is when somebody goes to court, they do that on a local level, and then sometimes these courts ask, somebody doesn't like the outcome, and they go to the higher court, etc. And in the end, the highest court of a country will ask questions to the European Court of Justice to clear some of the parts of that judgment and to take a look at it. So it's really the highest court. So if there's case law on the European Court of Justice, then that's the best source that we can have on how to interpret the law. But indeed, before you get there, it's on a local level. And there should be absolutely a coherence, you would say, in theory, but different member states also take different perspective. We have seen that in Ireland, where also the supervisory authority long did not really enforce on the big tech. This is a bit of a big happening in Europe, so to say. Has been. It's quite a soap, so to say. So it's interesting to follow. I hope that answers the question.
Yeah, I got it. Thank you. Thank you.
Anybody else? One more.
Any other law or compliance which is applicable towards the data privacy, the scope of customer protection of data, but in terms of specifically for semiconductor industry, which is apart from the GDPR? Is it something which is in process across globally, or have you heard across? This is the first part of the question. The second question I wanted to ask, is there any kind of fine or legal fines that you have come across which NXP has faced in the last 2 decades, or semiconductors industry has faced specifically for the violation of data privacy? And my scope is only towards customer data. So this question is open both to Shankar and to Wouter. Yeah, thank you.
There is, to answer the first part, no, there's no specific law that involves personal data specifically for semiconductor industry. There is, of course, besides GDPR, there is the e-privacy directive that regulates communication data, right? So that also protects digital communication. So that is most applicable to telecommunication services. But we all know it as the spam law or the cookie law in the rest of the world. That's basically the short term they got. But that also involves the regulation of cookies and your right not to be spammed. And it prevails, or no, it comes first. It states if you are allowed to do something, and then if you are allowed, then still you need to adhere to GDPR. So there are, GDPR is not something that stands alone, and you see that now also with all the developments in Europe, with the AI Act, the Digital Services Act, the Data Act. There are so many things coming, and they all, are simultaneously or sometimes applicable. It's a difficult landscape to maneuver sometimes, but that is something to take into consideration. Luckily, I can answer the other question with no, because otherwise I have to say I can't disclose any of that information. But luckily, I can disclose that we did not have any fines ourselves. I am not aware of any semiconductor company that was fined directly. I do like that question, but no, so far, to my knowledge, not.
Thanks, Wouter, yeah, for taking all our questions. And with that, one more question.
Is that you mentioned privacy is a fundamental right of EU citizens. So maybe very silly or dumb question. What happens if someone travels out of a EU location where privacy is not a fundamental right? Thank you.
It's that's the global impact of laws. Your fundamental right will never be taken away. But if you are captured in a country and put in jail, it's not so easy that you say I have a fundamental right to do this, so leave me and let me go. This is of course very difficult. So it's in there it's hard. It's just you see that it's a fundamental right, and then it's that right is further explained in other laws. That's also why we have the fundamental right to data protection by Article 8. But Article 8 is just that it states that it's not that long, and then to interpret that or to regulate that, they came up with GDPR, and GDPR is then applicable with its whole scope and states what needs to be done, etc. And that states that if you are targeting services or goods to the European citizens, or if you are processing data of European citizens or in the EU, right? That's the scope. Then the whole GDPR is applicable. So in that way, your right to data protection is at least enforced. They can still violate it, and they, in some cases, get away with it because it's of course a very long process to really enforce and fine. But that's the way it works. But yeah, of course, there are many other fundamental rights like free speech, and which is often also a bit sometimes bouncing against privacy, right? So that it's enforced on different ways.
Answered? You have one more? This is the last question, then we are moving to the quiz.
For you, while designing a chip, you say we are going with privacy by design, like project management phases. And what about security by design? Means we had side channel attacks. By side channel, we can get out the data from the transistors. And how do you going to address of that instead of privacy and security? Privacy by design is a one concept, and security by design, how to avoid the side channel attacks in the chips.
Yeah, I can also take that question, Wouter, with my security background here.
Yeah.
Even when you go out in NXP semiconductors, I don't want to do any marketing here, but whatever chip that you see in your bank cards, that credit card or debit card comes from NXP. So obviously, we have other standards which are coming from the European Union itself, especially, or when we supply or we make the e-passport for US. There are other standards which are coming, which is called common criteria, what we implement, which takes into account not just the physical security and the logical security, but also the product security
Hardware
features.
security.
Yeah, the security elements, how it needs to be developed, and there is an evaluator doing a testing of those security features. Not only that, there are three governments, mainly, as I know, German government, French government, and the Dutch government. Actually, they are directly involved in certifying the product itself with respect to the security features that goes into it, which qualifies our products to be sold to, for example, US government for e-passport, or the other banking sector, which I mentioned, the bank cards, the UID, for example, or the electoral machines, etc. So we have other standards is our answer.
Okay.
Concerned about security.
Okay, good. I think we are good with the questions. Since you are the one facilitating or the entire session, I be the facilitator now. Ota, thank you for your wonderful keynote. Appreciate your inputs. And Shankar, you are the host today, but also a great orator. I think a lot of inputs came in. Thank you very much. Felicitation for Shankar. Navi sir. Can I request Navi sir to felicitate Shankar? Would share this memento all the way to Netherlands, I guess. But thanks for being there.
My pleasure. No problem.
I think we are going to give you a memento. It will be given to Shankar, which will be sent to you whenever you are traveling to India. You can have it. Ota, that's for you.
Yes, that sounds like a very good reason to come next time. If I hear earlier on, then I might even be able to travel. But this time it was impossible.
Okay, we never know that. We never know that. We would have called you in that case. Okay. Thank you. And just be there. I think we do have another panel discussions. Just be there on this channel. Yeah. Okay. With that, thank you. And we are going to the quiz session. Are you ready? Yeah? How much you know about cybersecurity, data protection in semiconductors? Yes, that's what you discussed, no? Anything else? Yes. Okay. Now the quiz. Ready? Yes. I'll see. No, already no, that doesn't work. That doesn't work. Not allowed. NXP.
Due to the sensitive nature of intellectual property, trade secrets, and proprietary. Option B.
Are you confident that it's answer B? Why the voice is coming low?
No, I'm confident. Yeah. Because the panelists said in the discussion itself, obviously the semiconductor, this is a product-based industry, right? So they have their own intellectual property, they have their trade secrets. We have so many companies which are into semiconductor development. So they are creating their own patents, they have their own intellectual property. So they have to make sure that their trade secrets are, the confidentiality is being made.
Can we give it to her? Yes. Okay. You get it. Your name, ma'am?
Ankita.
Ankita, congratulations. Stand up. We'll take a proper photo.
Sir, A, implementing secure data storage and access controls.
You got it right? And the gift need to be given, right? Yes. See. Suren gets it? Yeah, thank you. Industry. We are going a little different direction, which is about the question which just asked by one of the lady here. Are there any data breaches happening in semiconductor industry? I think there was a session, there's a question even in the panel, in the virtual session. Okay, are there any incidents happening? How are you handling? So the next panel discussion is actually answering that one. Cohesive approach to managing data breaches. By Smita Chandrasekhar. May I request Smita Chandrasekhar to come onto stage, please? Wouter. I think he's already there on the panel. Dr. Avinash Tadich.